fellow citizens of India. They have asked me to talk about right to information and the courts in India and the judiciary. And I will take a little time also to talk about what I believe can be done to speed up the judicial process. But let me start with this. The courts in India have made outstanding pronouncements on the right to information being the fundamental right of citizens. Starting with 75, when Justice Matthews made a statement that still rings in our ears. S.P. Gupta, the ADR judgment is a landmark judgment which defines the right to information of citizens. But when the Right to Information Act was enacted in 2005, the courts took a certain backseat because they never realized that a fundamental right of citizens can be exercised in the courts as well. This was a story that they never understood before. The result was Delhi High Court framed rules for which they have been given the authority, saying the application fee will be 500 rupees. The law says the fee shall be reasonable. The government, for all the ills that we bestow on them, decided to charge 10 rupees. The High Courts said we will charge 500 rupees. Mumbai High Court went one better. They refused to frame the rules. This is a fact. For 1 year after the Right to Information Act was implemented, Mumbai High Court said, I am a law above everybody else. They talk of everyone saying nobody is above the law, no matter how high they be. But in all this, they don't include themselves. One of the problems perhaps is that we call them lords. If you are Vittal, if you are Krishna, then laws cannot apply to you. And I would submit that it's about time that we decided to stop this practice of almost bowing, scraping before them. We, the sovereign citizens of this country, must insist that our rights as citizens must be respected by courts, not the other way around. Whereas what is happening currently is, and one of the reasons why this is happening is, it's the contempt laws as they are practiced by the courts that have, if I may use a very strong term, terrorized citizens and media. At the tea time, Manoj, somebody from a very leading newspaper, was talking to Manoj and saying that for something that can never be imagined as contempt of court, an article had been printed criticizing the clerical staff in the courts. The court slapped a contempt of petition against this newspaper. It's a very leading newspaper. And as he said, without even thinking, we just said, we'll apologize. My friend Manoj Mitta will very well, without batting an eyelid, criticize Dawood Ibrahim, or the Chief Minister, or the Prime Minister of this country, or even Mukesh Ambani, Anil Ambani, you name it. But if it comes to the courts, he will be hesitant because he's terrorized into silence. And this is not a good sign because, no, this is not meant as criticism of the courts. When you cannot criticize an institution, you do not even know how bad it might be. Prashant has been trying, but he is also, well, I mean, Prashant is a giant in himself, so therefore it's difficult to silence him. But the average citizen does get silenced. That is the truth. The average media person does get silenced. People are reluctant to write anything. Having said this, what is possible in the judiciary? We talk of more judges, etc. Certainly that's a good point to start with. But let me point out, a US judge disposes over 3 times the number of cases that an Indian judge does. Adjournments, with the Supreme Court has ruled time and again, should be the exception, are actually the rule. There is absolutely no reason to give adjournment. The best, we have a judicial system which claims to provide the best natural justice in the world. And yesterday a friend, one of the speakers had made that statement which I found very appropriate. He said the best is often the enemy of the good. we neither have the best nor do we have the good. And we are left high and dry without any judicial system, as my friend Prashant explained. And this is what we need to change. Simple things. As an information commissioner, I can, well, I'm a mere central information commissioner. Let me assure Narayan Bhai, no, I can never be the chief information commissioner, because July 2012, I'll retire and come back and become an RTI activist all over again. But as a mere central information commissioner, I admit the cases before us are not great complexities of law. But I believe this is true of most cases anywhere, whether in courts or before a commission. We've ensured that no person who comes for a hearing has to wait for more than 2 hours. The average time is about 1 hour. Wait in the commission. It's not even a full day. I believe this is unacceptable. It's not more than 2 hours. In 1 hour average time, everybody comes, gets the decision in their hands and leaves. And 99% of the cases are not adjourned. The point is, as I said, the best can often be the enemy of the good. You say, well, somebody has a problem, so what does he do? Let me for a moment assume that this person does not get the best justice. The decision is still delivered without hearing him, maybe. So therefore, principles of natural justice are violated, is what my friends from the judiciary would say. And I would say, sir, I'm looking not just at the person before me, but the person in the queue. There is somebody waiting in that queue. And if I'm not sensitive to that person in the queue, I don't deserve to be fulfilling this task. Because if, as Prashant said, those who can access that court and those who can hire lawyers who benefit from each adjournment, they monetarily benefit with each adjournment, what happens to the poor? And Prashant mentioned the poor, but let me give you statistics. In Maharashtra, I found out 3 years back